We've heard a lot about how the non-dom changes might affect trusts, and I'm delighted to be joined today by Sonia Rees and John Bull to talk about how these changes may affect US connected structures. So John, it's been quite common planning for US people to fund trusts before they become deemed domiciled in the UK. What changes do we think we're going to see?
Quite right, Rachel. So really common practice for an American in the UK to fund what is a grantor trust for US income tax purposes before they become deemed domiciled. We've heard from colleagues, we know that such trusts will be tax transparent from April next year, with income and gains being attributed to our US citizen, UK resident, settlor grantor. That aligns quite nicely actually with the US tax position, because we have income and gains arising to grantor settlor both in the US and the UK on a rising basis, and can work quite nicely because there's particular provision in the US-UK income tax treaty that allows us to claim credits between the two jurisdictions. So ultimately we're just facing an increase in the tax rate on said income and gains to the UK tax rate, which is typically higher than US rates. The problem that we do have is that where such trust structures might have been used as like a locked box, so no benefits coming out to beneficiaries who might be in the UK, which might have crystallised UK tax charges historically, we now need to look at the assets of the trust and think about whether they're tax efficient from a UK perspective. It's been quite common in the client base for certain trust structures, like the ones we're talking about now, to be funded with assets which are not UK tax efficient. Think about US LLCs, think about US S Corps, etc., etc. So there's an action for individuals with those types of structures in their world to think about what the assets look like and potentially restructure prior to April.
Great, that's really helpful. Sounds like there's a lot to do. What about non-grantor trusts? Do you see any changes happening there?
Yeah, ultimately same provisions apply, albeit in practice we don't see non-grantor trusts as commonly as we do grantor trusts in the kind of scenarios that we've been talking about. But we do envisage some scenarios where we will see non-grantor trusts, where there's a UK resident, American grantor settlor that will be impacted by the income and capital gains tax provisions. A common scenario might be American has funded US trusts for benefit of the next generation, for example. Maybe they themselves are excluded from benefit. Perhaps it's a completed gift trust from a US gift and estate tax perspective. In that scenario, if our grantor settlor's resident in the UK and doesn't benefit from the FIG regime, then whilst income might still be protected from UK tax, realised capital gains from April next year will not be protected from UK tax.
So once again, people need to really start thinking about their structures at this point.
Very much.
So Sonia, we've heard a bit about trusts. What about any changes to inheritance tax?
Yes, certainly there are some changes to inheritance tax, Rachel. They are not quite as bad as some of us feared pre-budget. There is an element of grandfathering for trusts that were settled before 30th of October 2024, where you've got a long-term resident that is bringing these trusts into the UK scope. The good news is that those trusts will not be in what we call the gift for the reservation of benefit rules, so those settlors will not have those trust assets in their death estate. So that 40% tax charge, that was a lot of the headlines, causing a lot of the upset, that has fallen away. Hidden a bit in some of the nitty-gritty detail, which we always get to with trusts, is that actually those trusts will be in scope for what we call the inheritance tax relevant property regime.
Okay.
What that means is that those trusts, when they are within the long-term settlor, is within the scope to IHT, that trust is going to fall into the relevant property regime. They will have 10-year IHT charges of up to 6%. That is for the length of time that the settlor remains within the IHT net. So that could be spanning a long period of time. If the settlor becomes outside the scope, so they leave the UK, they lose their inheritance tax tail that some of our colleagues have been talking about, at that point the trust will fall out of the regime. Sounds good news. Unfortunately, as well as the 10-year charges, we will have an exit charge, both at the point that these trusts fall out of that regime, and also if during the 10-year regime there are exit charges if you have capital coming out. These are all going to be really, really new concepts, especially to our American trustees. We have to make sure there's going to be some good communication going forwards between trustees and settlors. Trustees don't necessarily know where their settlors are. Their settlors are the thing that are going to trigger these IHT rules. But our trustees are the ones that have a responsibility for reporting within a pretty set period. It's going to be quick that they need to understand these things and paying the tax to HMRC. There's also going to be issues for trustees over valuations, making sure that they're taking advice early enough so that they have the information they need. Depending on their asset type, that might be easy if it's quoted stocks and shares. If you're holding some more complicated assets, those valuations might be more difficult. So there's a whole new landscape both for the trustees and also the settlors off the back of these rules.
Right, so it sounds like our really need for advisors and settlors to be working together.
Absolutely.
And communicating.
Just one point to add there. You're right, it is a really alien concept for our American connected trusts. We do have the estate and gift tax treaty, which we might be able to lean on in certain circumstances where trust is in the scope of these inheritance tax charges that you talk about, Sonia. That will really depend on the particular facts and circumstances of the grantor settlor, where they were when trust was settled. But it may be a way that we can look to take trust out of this regime.
Once again, lots of kind of words of caution. So John, it sounds like Sonia said it's not as bad as we might have originally feared, but there is still IHT exposure for some. What might those people want to do or consider?
Yeah, you're right. The prospect of that ongoing inheritance tax exposure, assuming our grantor settlor remains in the UK, that's always an option, leave the UK. Assuming they remain in the UK, then that 6% charge every 10 years might be quite unpalatable, especially as there's no comparative in the States. So what are people thinking about doing as a result? Well, naturally, we just mentioned leaving the UK. That's always an option, and there's some slight hangover provisions in terms of when they leave, and the long-term resident position that Sonia you talked about just now. We're also seeing clients, early conversations thinking about actually is the trust structure still of benefit to them. Notwithstanding trusts are great for non-tax reasons, here's a tax regime which might mean that actually the trust structure just doesn't achieve goals of the family anymore. So is there something that can be done either pre or post April to wind up the trust in a tax efficient manner? If we've got an American that's here and can still claim the remittance basis one last time before April 2025, then they can potentially wind up the grantor excluded property trust structure in a fairly tax efficient manner. If we've got someone that isn't in that position, so perhaps they're already deemed domiciled in the UK, they don't have that remittance basis to lean on, naturally. We might have some provisions in the temporary repatriation facility, again, which we've covered elsewhere, that could allow access to some beneficial tax rates if trust is wound up post-April 2025.
I think it's also worth mentioning at that point, actually, although you can break that 10-year charge regime by leaving in certain circumstances, the big risk for some clients is that if you die whilst you're a long-term resident and you're in that relevant property regime, that endures for the duration of the trust. And so you might want to look at winding up, like John was discussing, in order to get out of that risk and mitigate your IHT risk in other ways with life insurance or other things.
And I think, would I be right in thinking that winding up a trust is not something you can literally do overnight?
Yeah, exactly right, Rachel. Yeah, so whilst there's clearly lots to think through in terms of what the tax exposure is, and naturally we can help with that, we certainly wouldn't be wanting clients to be thinking about winding up a trust in March next year. Whilst these things can be done in a fairly short space of time from a legal point of view, and we do need lawyers to assist with that, there's a lot to think about, and I think the message from us is take some action soon and start thinking about it.
Now, we've been talking about, obviously, structures that already exist, people are already kind of here and involved. What about newcomers to the UK, Sonia? What do we need to think about with them?
So newcomers to the UK, I think, again, there's a lot of discussion over, there's this new 4-year regime where people come in, they don't have to worry about UK tax, and lots of people's heads, I would say that is not the new world for us. I think you still want to take advice early. Before Americans are coming here, they need to understand, if they are the settlor of a trust, what that's going to mean in 10 years' time. Do they want to wind the trust up before they come? Have they got a plan for what that might look like if they stay? Who does it affect? What does it mean for the trustees? Who are the beneficiaries? Where are they? There's all sorts of questions that still want to be thought about up front before resuming residency, wherever possible.
Great. So I think in conclusion, some good news, some not so good news, but certainly now is the time to be looking at structures, certainly ahead of April 2025, and once again ensuring that we have kind of well-rounded conversations with advisors and our clients. So it sounds like there's quite a lot to consider, and timely conversations are really of the essence. So if you'd like to learn more, get in touch with any one of the three of us or your usual Blick Rothenberg contact. Thank you.